Well, good morning. They told us to speak directly into the microphone, but this is going to give me God complex. On behalf of the court, we just want to thank Nova for inviting us to come. Judge Laurer, Judge Jaquith, and I are excited to be here this morning. This is, I think, our third in the series of arguments at the Nova Conference in Washington, and we hope that this continues into the future. So this morning we are convened to hear argument in the matter of Alexandra M. Jackson versus Dennis McDonough, Secretary of Veterans Affairs, case number 22-3528. Would counsel, beginning with Appellant's counsel, enter your appearance for the record?
Your Honor, Zachary Stolz for the Appellant. With me at counsel table is Jenna Zellmer, which is
Good morning. Secretary's counsel.
Kirschner, Your Honor.
Thanks very much. Mr. Stolz, I understand you want to reserve some time for rebuttal?
Yes, Your Honor. 10 minutes, please.
Then we'll make that happen, and you can begin when you're ready.
Thank you, Your Honor. Good morning, Judge Allen, Your Honors. May it please the Court. As an initial matter, because we are at Nova, there are materials associated with this. The synopsis of the decision here today, just for the purposes of following along, has that the appellant is arguing a December 2009 rating decision as the initial decision with respect to this case. It is, in fact, March 2008. It changes nothing about our argument, but I wanted to get that out there just because, to clear that up.
Well, you found the thing that we implanted to make sure that you read our summary. Thank you, Mr. Stolz.
Part of it is our fault that we got it wrong in our reply brief, so we apologize for that, and so I wanted to clear that up. Under 38 United States Code, Section 5904, C1, a representative may charge fees for services after a claimant is provided notice of the agency of original jurisdiction's initial decision with respect to the case. The initial decision here is that March 2008 rating decision, awarding service connection and a compensation rating for the veteran's hip condition. This is because it is the first decision with respect to the case, which is the compensation rating provided for the veteran's hip condition. As the Federal Circuit emphasized in MVA, a case encompasses all potential claims raised by the evidence, applying all relevant laws and regulations, regardless of whether that claim is specifically labeled.
Could I jump in right now and
Yes,
let's pretend that we're living in a world, it's a bucolic world, in which the AMA has not descended into our life. Okay, so it's just the legacy system just continues. Would you agree that if we were in the legacy system, there's no AMA changes, that under our court's holding in Cameron, your client's position would lose?
Yes.
Okay, so then what we're saying is that with respect to the case, that language, even though that language itself did not change when the AMA was adopted, something else did so that the meaning of those words with respect to the case, even though they're the same words pre-AMA and post-AMA, they're different. That's got to be what it means, right?
Well, with respect to the case was defined in MVA. And so case is becoming broader with each iteration of the attorney fees, statutes. Originally, you could only charge $10, and then it was the NOD, and now it's after a decision with respect to the initial claim. But with respect to the case, it's becoming broader, but MVA did clarify it, and they did bring Carpenter. They relied on the Carpenter decision, which predates the AMA, to explain what a case was. The reason we would lose under Cameron is that in Cameron, there was new evidence coming in. It was a new claim under that old framework and under that old framework. But it doesn't mean that with respect to the case, its underlying decision, the definition articulated in Carpenter, which was relied upon in MVA, which is a post-AMA case, is what defines what a case is. It's further fleshed out, Your Honor, and so to Your Honor's point, it does change a bit because it is fleshed out and explained more by the definition of supplemental claim and the statutory framework regarding that.
And so with respect to this, is there any scenario and because we're appearing at Nova, what I'm going to say now is not pejorative, right? But is there any reason other than fees that it matters on an increased rating claim whether it's called an initial claim or a supplemental claim? And to set this up, right, what I mean is the notion of continuous pursuit, which is important for supplemental claims within a year, right, really doesn't have the same meaning with respect to an increased rating claim.
It doesn't with respect to a supplemental claim either after MVA.
Well, true, but I'm trying to come up with a reason why, other than for purposes of fees, it matters whether this is called an initial claim or a supplemental claim. And the reason I'm asking is, the only thing I could think of where the distinction really would matter generically is because if you've continuously pursued something, you can go all the way back to the initial thing, right? But for an increased rating claim, that wouldn't be the case because the whole notion is it's increased.
We have found, to Your Honor's point, whether legally it matters is important because it gets back to the thrust of the AMA. The entire idea of the AMA, right, was to streamline the system. And so if we call things something they're not, it confuses the system. And so this is an attorney's fees case. It is important. It's vital for attorney's fees. But it is important to veterans because what is happening is VA, and we submitted the supplemental authority from the M21. What VA is doing is whenever you file a claim for increase, they're saying put it on a 526EZ. And what we have found they are doing in some cases is they're starting to mark the effective dates only from when those claims come in, even if it is continuously pursued. And so the confusion surrounding what is a supplemental claim, increased rating claim, all that does hurt veterans because it does bog down the system.
Well, but the effective date for an increased rating claim, whether we call it a supplemental claim or not, right, would only be either the date of the claim or the period within 1 year earlier at which it's ascertainable that the condition worsened, right?
Yes, if VA did that correctly, yes.
Right, but my point is, us saying so my only point is, I couldn't think of, and it sounds like we don't have it here, that there's a legal significance to whether it's a supplemental claim or an initial claim on an increased rating, other than for attorney's fees, which I'm not saying is unimportant. I'm saying, but that then focuses us on, it's the attorney fee issue that's the key here.
The attorney fee issue is key in this case. It is important to clean this all up as we all in this room and Your Honors and VA deals with the AMA. It is important to clean it up. These words do matter. It will lead to less confusion in the system. It will help to achieve Congress's goal of streamlining things. But to Your Honor's point, it is primarily an attorney's fees case.
Mr. Stolz, if I may, how would the appellant address, we've got a lot of tools when interpreting the statute here, how would the appellant address the presumption of legislative acquiescence with respect to, you mentioned Carpenter, but there is also the Cameron case which was mentioned. How would you address that there? In other words, that case predates the changes under the AMA, and it was known, it's obviously precedent for our court.
I would say that Congress only uses two things. They use initial decision, they use supplemental claims. And so they didn't contemplate increased rating claim. And back to Judge Allen's point, under the analysis for whether someone can legally charge a fee, under that analysis, there's no consideration of this increased rating claim being an initial claim. And so there's nothing, Cameron was just in the old world. And it's interesting that VA relies upon Cameron, and VA also submitted the Gumpenberger case, the Secretary submitted the Gumpenberger case, both of those illustrate what I think is a fundamental problem in this case, and it's the Secretary trying to legacyize the way fees are considered. One of the points that, as I prepared for this oral argument, really became clear to me, at least in reading their pleadings, is they're really defining supplemental claim just as the old world's version of a claim based on new and material evidence, and that's it. And so they're not going along with the broadening of the availability of attorneys and accredited representatives' fees here. And so, to Your Honor's point, Cameron just really doesn't have anything to tell us in this case. The Carpenter case was relied on for its reasoning in MBA, and so came into this our new world. But Cameron, it was just a different system, and it was based on a time in which you had a closed claim, and then new evidence came in to reopen a claim. After MBA, that's gone, because now a supplemental claim doesn't necessarily start up a new stream of benefits. It relates back to that case, and so that's what's contemplated by the plain language of the statutes.
So, are you saying that MVA decides the question so that we're just bound, we just apply it, or are you saying it's instructive? Because I don't read the case as actually, who knows, maybe the Federal Circuit says, nope, that we were thinking precisely about attorney's fees questions when we did this, and that's what we were talking about. Now, they were talking about the fact that VA classified supplemental claims beyond 1 year different from supplemental claims within 1 year, and the court said there's no basis in the statute to do that. That's as far as I see it going in terms of a holding. So is the appellant's position that it binds us in the sense that it has already decided the question that we are here to decide, or that it's instructive, it points in a direction?
It is instructive. Both MVA and this court's recent decision in Held are instructive insofar as really the last part of 14.6 of the regulation in MVA, 14.636B1. Thank you, Your Honor. 14.63B1, little 1. The last part of it, really, that has not been struck down is this part having to do with VA mischaracterizing or lumping. It's not even a mischaracterization. It's the lumping in of a claim for increase under the penumbra of initial claims. When it's not an initial claim, it falls squarely under a supplemental claim. The way to think about it is it's the interplay between 5904C1, 5104 big CB, and 10136. That's really all one needs to figure out whether there is entitlement to a legal charge of attorney's fees here. And that is because the initial decision with respect to the HIP case has been made. The veteran's entitled to file a supplemental claim even after a year has passed. And this claim is for the same or similar benefits on the same or similar basis as when they were awarded compensation the compensation rating back in 2008. And same or similar basis refers to the factual basis upon which a claim for benefits is based. In other words, the underlying disability for which the benefit is sought. That's from the Boggs case. And as the Federal Circuit explained in Carpenter, degree of disability and effective date of disability are issues within the same case for the claim of benefits, including the issues emanating from the disability or injury that led to the claim. That's all you need. Which is why VA's regulations here don't really follow that, which is why 3.1P12 and the remainder, the little that remains of 14.636B1, little 1, really need to be struck down. You don't need to get there because the plain language of the statute gets you there, but it would be very helpful to veterans and veterans advocates if those regulations were struck down as not in accordance with law.
Didn't Gumpenberger highlight that considering the later claim part of the case that gave rise to the initial decision requires a connection between the earlier and later events, such as continued proceedings or continuous prosecution of the case?
It did, but Gumpenberger specifically in footnote 72 talked about how I read Gumpenberger as limited to the NOD statutes and regulatory framework. The court even dropped a footnote saying this isn't necessarily in the world of MVA and the AMA. But to the extent that that reasoning was a part of Gumpenberger, it's still a bit of a red herring, because this has nothing to do, and this is what I think the fundamental mistake in the AMA has been with VA, and this has been an ongoing battle with VA over entitlement to fees, is that the original sin there, if you will, is that VA keeps trying to say you charge fees when VA has done something wrong that you have to go back and correct. That's not what triggers attorneys' entitlement to fees for attorneys and accredited representatives anymore. It's just if it comes after the notice of the initial decision. And so Gumpenberger really, I don't read Gumpenberger as to really advise or instruct on anything at issue in this case, because it's in this new world. It's in the AMA world.
But Gumpenberger is not a done wrong case. It's a connectedness case.
And it's a strict, and it's, if I recall correctly, in that the appellant kept limiting the case by the NODs, by themselves saying we're limiting it to this, we're limiting it to that. That's not in this case. If there was a limitation on what someone was seeking, I think that would be a different question. But I read Gumpenberger as to be, they were limiting the universe of what they were seeking and not seeking kind of what the maximum was.
Is there a break in the connection here in the failure to timely react or failure to appeal the December 2018 board decision?
There's a break in the action because of that, but not for the purposes of attorneys not for the purposes of the entitlement to attorneys' fees. It certainly affects how much money was awarded, right? It certainly affects the effective date of the increased rating because it came outside of when the period closed for the continuous pursuit. But that's really all that it has to do with there. It doesn't go to entitlement. It just goes to the amount of the benefit and the effective date.
Doesn't it, by dissolving that connection, give credence to the Secretary's position that what follows is separate, new?
It does not. Because of, again, MVA very instructive here, held also very instructive, because you don't have to file, because an appellant doesn't have to file within that year. That's the chain that MVA broke, that Gumpenberger is not really contemplating, because the fact that MVA didn't really apply in that context because it was in that old world. It was in the Cameron world. It was in the old statutory framework. And so, yes, there is a break in the action, Your Honor. Absolutely, there's a break. But now, because of the statutory framework and the instruction of MVA, that it doesn't matter that a supplemental claim can come in outside of that year. If this is, in fact, a supplemental claim, which it is for the reasons I just read, it doesn't matter for the purposes of attorney's fees that there was that break.
Why not call it a supplemental claim when it was made?
As we move forward, this needs to be called a supplemental claim. In fairness, just realistically, it is confusing, and that's why we submitted the M21 provisions that we did and about how VA is processing these just in a realistic world. I have two answers really to it. One, we all knew, right? Otherwise we wouldn't be here. The board knew, and VA knew what Ms. Jackson was pursuing on her client's behalf. But also, just as a practical matter, VA says file these things on a 526. And so going forward, yes, this needs to be filed. Supplemental claims need to go in as supplemental claims. A supplemental claim for increase would probably be the better way to call this. It wasn't in this case, but it makes sense realistically why it wasn't. And I don't think it's really, I know the Secretary made a point in his brief about how well they used the wrong form. That's the form that they told people, advocates, and veterans to use. And so that's why it's on a 526EZ as opposed to an 0995.
And in the legacy system, when you, not you personally, but an appellant seeks an increase, they would use the initial claim form?
Yes.
Right. So here's the thing, and I just want to go back to this, and if you go over, I'll give you a little bit extra time. But I keep getting hung up on the fact that the phrase, because as you know, I was involved in both Gumpenberger and Held, and so the phrase, with respect to the case, has been like the constant that has stayed in the statute along the way, and I keep getting hung up on whether Cameron was right or not. It focused on this notion that the case, when you are filing for an increased rating, is different. It's not right. And so I keep going back to the fact that Congress would have had to change that. And the reason I say about the form point, I agree with you. The fact that you use this form, I don't think binds you. The regulation or the M21 or M25 or whatever says, you have to use it. But it's because you all considered, I think, at the time that with respect to the case stayed the same. So why should we assume that Congress actually changed it?
Because Congress, it's more than just 5904C, right? You have to read more than just the words of 5904C. You have to bring in Section 38 U.S.C. 10136 does a lot of work here. It does a lot of work to inform what Your Honor is worried about, and that is that 10136 is new, and it comes in and it says, here's what supplemental claim is. And because it's based on that same or similar basis, that is instructing that it relates back to the initial decision on the case. It kind of just can't be otherwise.
Well, it could be, right? I mean, so same, it clearly by definition, and if we could add 5 minutes, Tiffany, or Dawn, Rosie, thanks, that it's not the same, right? I mean, for certain, because by definition, it can't be same, right? Because you're saying it's worse, right? And so then it has to be, well, it's similar because it's the same condition.
Same condition.
So, but that's my point, is that under the Cameron world, and again, I'm not saying I agree with Cameron, but at least in the legacy system, I'm bound by it. The court said, well, no, because by definition, it's different because you're saying there's something more than what we had originally because it's worse.
But in Cameron, there was no availability of the supplemental claim after the year period ended, and there was no definition of what that was on same or similar basis, and which is why we cited to Boggs and Carpenter to articulate why that same or similar basis is important here. And
so you think, I don't want to pigeonhole you, right? But you clearly understand what my focus is, which is that we have the same language before and after. The language didn't change, so something else Congress did has to have changed the meaning of the case.
The fact that there is now supplemental claim.
So, and that's what I'm getting. So you're at a point, me back to 10136, right? Excellent.
I do have a question. So under the AMA now, what is the role of veteran services organizations? This is obviously a fee for agents or attorneys case, but how do you see that working going forward under the AMA, where you have the VSOs that provide free representation, helping veterans and other claimants, and now, based on your argument, the entry point has, in this case, changed to a earlier point.
Absolutely vital. The VSO community remains absolutely vital. There are still millions of initial claims that have to be filed, whether that's an attorney or accredited agent doing those pro bono, that's fine, or a VSO. I think most people know I worked at DAV, so I have a soft spot for DAV in particular and the wonderful work they do. Remains vital. Just because an attorney or accredited agent is entitled to legally charge a fee, and there's a world in which legality of charging a fees is also coloring some of this, but that's not part of this case. But just because an attorney can legally charge a fee, it just increases the options, the legal options that veterans have. It does not in any way displace or downplay the vital role that the VSO community plays in our process.
It also leads to a question I had with respect to, you cited in the opening brief to the Trafter case and suggested a veteran-friendly approach here. I didn't follow that. How would
So
authorizing the payment of fees be veteran-friendly. The appellant here obviously is not a veteran, so how does that suggest
it can be read as
veteran?
veteran-friendly by increasing the access to different choices of representation. Congress that all really kind of began with Congress, Your Honor. Congress wanting to increase, not decrease, the access to accredited agents and attorneys that do charge for their services in a legal way, a heavy regulated and legal way. And so that was the reason for that citation, was read the way that I think it was meant by Congress, access to more representation and more choices benefits the veterans community as a whole. But it was certainly not meant to replace the vital VSO work.
Thank you.
As the veterans case progressed through various rating decisions in 2009 and 15 and 16 and up to December 2018, were there fee-generating events that actually resulted in payments pursuant to the agreement?
I believe there were. I don't specifically have those awards in this particular record, but I believe so, Your Honor. I can track that down with more specificity for Your Honor if you would like. But there were definitely fee-triggering events, whether fees were, to more completely answer Your Honor's question, there were definitely fee-triggering events because there were notices of disagreement and so forth filed. There was a final board decision. I don't know, and it's not in this record, I don't believe, as far as what was submitted to the court, what was awarded based on those. But if it is a point of contention, or a point of concern, I can certainly track that down.
Thank you.
Thank you, Mr. Stolz. We'll give you your full rebuttal time.
Thank you, Your Honors.
And as you're walking up there, Mr. Kirschner, you don't have to use it, but if you want to use it, you can have an additional 5 minutes as well. So.
Thank you, Your Honor. May it please the Court. Your Honors, the court should affirm the board's decision here because...
Could you speak a little bit more into the
Sure.
microphone? I didn't mean to
There we go. Here we go.
make you do work.
Is it
there.
catching me? Okay, may it please the Court.
Thank you.
Thank you, Your Honor. The Court should affirm the board's decision here because the Secretary's regulation fills a gap in the statutory scheme. It's not arbitrary or capricious, and failure to do so could actually result in harm to the veteran's interests in this case. Under the AMA, Congress stated that attorneys or agents may not charge fees for services provided before the decision on which a claimant is provided the notice of the AOJ's initial decision with respect to the case, as the Court has discussed with my friend here. The AMA also split the universe of claims into two types of claims, initial claims and supplemental claims. It defined a supplemental claim as the claim for benefits under laws administered by the Secretary, filed when a claimant has previously filed a claim for the same or similar benefits on the same or similar basis. Therefore, it stated specifically what a supplemental claim is, to the exclusion of all other claims. Congress did not define initial claim, and that left a gap for VA to fill, which it did in its regulation. The regulation...
Well, why wouldn't it be the case that if it is the case that the world is divided into two things, an initial and a supplemental claim, right? I think that's what you said.
Yes.
And I think that's right. If you define one of those two things, haven't you, by definition, defined the other? In other words, if you say a supplemental claim is one that's on the same or similar basis, then isn't it by definition something that isn't on the same or similar basis must fall into the initial claim?
That's exactly it, Your Honor.
So if that's the case, so I was struggling with this thought too, right? Because in a world in which there's binary, so there's a 0 or a 1, if you just define what 0 is, have you really left a gap to fill? Or by defining 0, when there's only one other option, if you don't fit in the definition of 0, you must be a 1, is there a gap? So my point being, interestingly, whether or not going to the regulation and thinking about whether it fills a gap, particularly in a world in which we don't know in a few months whether Chevron is going to tell us that's what we do, Maybe what this is really all about looking at 10136 and interpreting those words, because once we know what that is, we also, by definition, know everything else must be an initial claim. Do you see what I mean?
I think I do, Your Honor, but I think that goes along with the Secretary's position here. Regardless of whether there was a gap or whether there's some ambiguity in the scheme, nothing in the Secretary's regulation, and here I'm talking about 3.1p, goes against the idea that an initial claim should be what the Secretary says it is, because supplemental claim in the Secretary's regulation mirrors the definition that was provided by Congress in 10136. So there's nothing in 10136 that would provide conflict with the Secretary's definition of an initial claim here, at least nothing in the text of the statute itself. So, moving along.
But is that really true? I mean, a supplemental claim is at its base defined as a claim in addition to one that went before. There is talk about new and relevant evidence and responding to or expressing disagreement, but the basic requirement is just that there was a prior claim.
That is a basic requirement, but the language says, of course, same or similar basis and same or similar benefits. Those are the two kind of distinguishing factors of the supplemental claim. And in this case, when we look at the veteran's benefits, the veteran in this case, from the decision from December 2021, the rating decision, received different benefits. Though it was related to the hip disability, they were different benefits in terms of getting a temporary total benefit, and also the veteran received service connection for left hip scars. And of course, those scars did not exist before the surgery, so the service connection is a separate benefit. The other point is...
But isn't the claim for the same benefit disability compensation?
Disability compensation... No, Your Honor. I believe a claim for an increased rating is a claim for... I believe it's different enough, Your Honor, and that gets to the second part of the definition.
But if it is a slightly, isn't it then similar?
For disability compensation, it is a similar benefit, perhaps. But either way, then we move to same or similar basis. And here, the same or similar basis, the basis is different enough because the condition worsened.
But again, isn't it degree of functional impairment? Isn't that the basis? The similar basis, whether it's 10% or 30% or 70% or 100?
No, Your Honor. And this goes back, again, to this is where the court's previous line of questioning about what constitutes the same case kind of gets wrapped up into all of this. Because as the court went through and has talked about what constitutes the same case, it focused on whether there had been a change. And here, the Secretary believes that under the statute, the factual basis is different enough due to the change in the veteran's disability. It's a different factual basis because the veteran had a hip replacement that he had not had before. So the Secretary believes that that is sufficient to be a different basis to allow the idea of an initial claim for an increased rating.
Well, you had it before. It was just a different hip.
Correct, Your Honor. But it's a different disability.
That's different enough? It's not similar?
Different enough, Your Honor.
Your hips on each side, not similar?
Yes, Your Honor, different enough.
So does it all come down to fundamentally, does this case all come down to whether or not the word, because I think everybody agrees this isn't the same as the initial one, because you're saying my condition is worse, right? So I think Mr. Stolz said that, but I don't want to put words into his mouth. But so does this really all come down to when Congress created or drafted Section 10136 and used the word similar? Did it, by doing that, alter what the law had been before about what the quote, case was. Do you agree that that fundamentally, if we were going to encapsulate what the question is, as I understood Appellant's argument, they seem to say we would lose under Cameron, which talked about what is the case, right? It was an increased rating claim. But the world has changed in the AMA. And the way in which it has changed is that that phrase did not change, but an input changed, which is same or similar, particularly similar. Would you agree just generally that if I, at least one person, were looking at the case that way, that encapsulates what the real question is? Well, and while you think, because this is how, in just one, I have not spoken to my colleagues. I think that Cameron said under almost an identical situation, a fact, that you can't get a fee because it was not with respect to the same case, right? That phrase, which has stayed the same. So, for Appellant to prevail, they've got to convince me, at least, that Congress in the AMA did something that changed that law. Okay? And I think where we've been pointed is particularly the definition of what a supplemental claim is, which is new. And so I'm just looking for your reaction to how I'm considering this issue.
I think, Your Honor, that Congress really didn't do anything to change that language. And I don't think that even the definition of supplemental claim, as Congress put it out there, really should change that language. Because when we look at MVA and we look at Gumpenberger and Held, and it's as my friend over here stated, in a way, under the AMA, what a supplemental claim is, at least a supplemental claim filed more than a year after the decision, is akin to the request to reopen for new and material evidence under the legacy system. And, there's statutory support for that, because 5108 was what talked about new and material evidence, and now 5108 is what talks about a supplemental claim.
Well, but what if I pushed back and said, one of the things that the court in Cameron said, it was similar to Carpenter, I think, at the Federal Circuit, but clearly in Cameron, what they said is, well, by definition, when you're seeking an increased rating, you are adding this new stuff, right? And so that helps break the chain about what is the case, right?
Right.
What about the argument, and again, I'm channeling what Mr. Stolz just said, so my words, not his, that when Congress, though, now says a supplemental claim includes something that is similar, right? That it's enough to be similar to say I'm talking about the same condition, even if the two hips are different, I'm talking about the same condition and the same type of rating, it's worse, and that's close enough for government work, right? Something like that.
The Secretary doesn't think that is quite enough there, Your Honor. I think when you look at, again, MVA and Held and Gumpenberger, and especially how the Federal Circuit sort of analyzed, even looking at Carpenter and MVA, what they keep going back to is that all of these things, whether it's a request for higher level review, or an NOD under the AMA, or a supplemental claim, or now after MVA, a supplemental claim filed, more than a year later, it's a request for appellate review of some kind, and that's why when you get to, I believe it was Held, when you're talking about a Q challenge and the ability to get attorney's fees for a Q challenge, one can pretty just consider a Q challenge as a request for review. It's like the ultimate request for review. You got this really wrong. We'd like it reviewed. What MVA didn't touch was that sort of floor set out for attorney's fees in 5904 that, there has to be work performed after that initial decision. So everything that remains payable under 5904 after MVA and not really disputed by Held or Gumpenberger or these cases is that there has to be some kind of a request for review. And here we have a case where the attorney filed an initial claim for benefits and the veteran was awarded an increased evaluation and new service connection, and those effective dates were given as if it was an initial claim instead of filing a request for review, which would have been after MVA a supplemental claim. And that has a real impact on the veteran, because if the veteran would have filed, the attorney would have filed a supplemental claim more than 1 year after the board's 2018 decision, the effective date for those benefits would have been the date of claim and not the look back to the February hip replacement surgery. So in a way it's unfortunate, but there's a kind of a choice here between the attorney filing the initial claim for increase, which allows the veteran under 5110 to get a greater benefit based on effective dates, or they file a supplemental claim more than a year later, which would entitle the attorney to attorney's fees potentially to the veteran's detriment. But I don't think anything in MVA or those cases really gets rid of that fundamental principle that all of the, and even if you look at the AMA itself, in the heading for subsection 2, it talks about appellate review. There's a distinction between something that seeks appellate review and regardless of which lane it chooses, right? And something that is an initial request for a new benefit based on a change in circumstance, which is, what Cameron was about, and I think what actually kind of survives into the AMA, even after
Does Cameron
MVA.
have any legs after MVA? Doesn't it sort of reject the nitpicky things that we're talking about in favor of a much broader, more logic-based test as to what's part of the same case, when they said that a veteran's claim based on a specified disability doesn't become a different case at each stage of the often lengthy and complex proceedings, and specifically the issues of service connection and disability ratings are both issues within the same case?
I might not be recalling MVA 100% correctly, Your Honor, if you'll forgive me, but I believe shortly after that statement, they talk about all stages of the appellate process. And the appellate process, what makes it an appellate process is a request for some kind of administrative review. And that's what the AMA did. It said, instead of just having one option for administrative review like we had under Legacy, where you file an NOD and then you go on and on and on, you have three different options. You can ask for HLR. You can file a supplemental claim within 1 year, which can give you a benefit in terms of effective date. Or you file an NOD to the board. And so now an attorney can work on either of those three, perhaps using different strategies for each instead of just filing an NOD.
Or here, a much later supplemental claim.
Or here even, and that's what the MVA did. Because initially, and this is where it gets a little difficult, because I think that the system was set up with the AM, after the AMA, the Secretary is implementing regulations, of course had said that after a year, if you do a supplemental claim, that's not a request for review in the same way that within a year is. Or no, not that it's not a request for review, the attorney specifically can't get paid for that, and that was in the regulation. And what MVA did was looked at the text of the regulation and said, you know what, that distinction is not in the statute. It's extra to the statute.
So they invalidated the regulation.
So they invalidated that part of the regulation that treated supplemental claim differently, because supplemental claim wasn't treated differently in the statute. They used the same term two different times, and so it should mean essentially the same thing.
It's a little bit of a digression, but maybe this is a good point to ask. Doesn't the board's reliance on that invalidated regulation a year after MVA, isn't that an infirmity that requires remand?
I don't believe so, Your Honor. I'm not sure that it would have an impact here because, as my friend conceded, that they essentially believe that that part of the regulation remains not invalidated. The part that was invalidated was the part that dealt with treating two different supplemental claims differently. This is not about a supplemental claim. This is about an initial claim for an increased rating. In order to have this be
obviously
about...
that's a matter in considerable dispute.
No, absolutely, Your Honor. But in order for that regulation to be, the basis for the remand, I think the court would have to agree with my friend over here that, there is essentially no such thing as an initial claim for an increased rating anymore.
So let me just ask you this. Assume you have, and I understand what I'm going to say is a scenario that wouldn't often come up, okay? So assume that there's a rating decision. It grants a service connection for a knee condition and assigns a 40% rating, okay? More than a year passes. A person then files a true supplemental claim in which they say, listen, my knee has not gotten worse. It's exactly the same as it was on the date that I had my original decision granted. But I'm submitting this new evidence that's relevant that shows actually that the 40% was wrong. Okay, now I understand that would not often happen, right? But let's assume that scenario. In that scenario, assume the supplemental claim is granted and they're awarded a 60% rating. I take it the Secretary's position would be, yeah, that doesn't go back in terms of an effective date because it's more than a year, but that is a true supplemental claim. It is an appellate option, right?
Yes.
The Secretary would allow a fee in that case. Is that right? For the delta, at least, between the 40 and the 60, maybe, right?
That's correct, Your Honor.
And so really the distinction here, I'm thinking out loud, is less between supplemental claim after a year and supplemental claim within a year, and really the distinction between, I just want to make sure I'm getting the Secretary's argument, the distinction between a request that seeks review of a decision versus what the Secretary is claiming is an increase is a request for something new.
Correct, Your Honor. The linchpin here is the request for review.
And while I have you, just one question, because I saw Mr. Carpenter walk in here, which prompted me to ask this question. Yesterday, the Federal Circuit heard oral argument in Gumpenberger. I just want to get both parties' positions. Do you believe that Gumpenberger is so critical to the case that we should hold our decision, even if we didn't stay the case, to see what the Federal Circuit does, or not?
I don't think it's necessary, Your Honor. I think we 30 beat Gumpenberger more for the analysis than anything else, so I think that it would be okay.
Thank you.
As a practical matter, isn't it fair to say that a claim for disability compensation following a compensation decision self-evidently disagrees with that the existing decision is adequate? It's a claim for more, whatever its basis. Express disagreement with the prior decision on that body part or a worsening degenerative condition.
Again, Your Honor, I think that the Secretary's position here, the real linchpin is that it's a request for review. You could consider it, perhaps a disagreement, but that disagreement would be based on a changed circumstance. Either believing they're entitled to a separate benefit or, something has happened in their life or with their disability that wasn't part of the prior, the prior decision, the prior claim, the prior record even. Something new comes up, and that's when they say, I would like this new benefit. And it's not saying that we need to review this what was done before. It's not a request for administrative review. It's a request. The easiest way to put it is it's a request for something more and different.
A review is what's still required, right?
In order to give attorneys fees, yes.
And but isn't that what happens when that kind of a claim is filed? When the claim is filed, I want more. I want a higher rate.
I don't think that it is necessarily a review, Your Honor, because the review would be on the prior basis. Something new comes in, it makes it, in essence, a new basis. And though the old adjudication and the old record would be part of that, it is not that entirely. It is not a pure review request. The way that, again, to use the analogy here, a request to reopen based on new and material has been found to be, or was found to be, or a request for Q would be, or an old NOD would be, or any of the three new review options would be.
And it's your position that margin forecloses fees?
Congress has said that margin forecloses fees because Congress essentially set that floor about, the agency needs to be able to kind of do its initial decision, and then after that, when there's some kind of administrative review, fees can be sought. I thought it interesting, the Secretary in his the commentary on the final rule kind of discussed this situation. I'm sorry I didn't have the pin site in my brief around, it was 84 Federal Register at 150. And they noted that they were doing so because they didn't see anything in the AMA that went against, prior statutes' desire to let VA have sort of an initial crack at making the initial decision before fees could be charged. So I think that, the Secretary's regulation is also explained in that way. And I really do think the linchpin here comes back to review. And the review options, are set out in the AMA. There are three of them, including the supplemental claim, but the supplemental claim remains a request for review. It may have different attributes from other requests for review, such as, needing to submit new and relevant evidence, but I think a request for review, it still remains, and thus it's different from an initial claim for an increase.
Does the Secretary have any discretion with respect to agent and attorney fees under the AMA? What is the position of the Secretary on that? Is it all in the statute, or is there some other discretion?
Well, I think that what is in the statute is the floor. There is that requirement that there has to be that initial decision sent out, and then after that, the work performed, if it's successful, the attorney can charge a fee for. I'm not sure. I don't think the Secretary's regulations, as they're laid out, really request more than that. They request some kind of review option, or they note the different review options. But apart from that, I think it's only the floor in statute.
And what impact, if any, both parties in the Rule 30B filings in this case cited the Held case, which was decided in November of 2023 after briefing closed here. What is the impact of that case on the Secretary's position here?
So, Held doesn't have a lot of an impact on this case. I laid out the reasoning before in my argument. Essentially, Held involved, a Q challenge. During the AMA time period, I see I only have 3 minutes. Do you mind if I finish, Your Honor?
But remember, you get the extra 5 if you need it, so there you go.
Thank you, Your Honor.
And keep in mind, too.
I'm a giver, so
Okay.
there we go.
Fantastic.
Keep in mind, two of the panel members are on this panel from that case, but
Yes,
just
yes.
curious because both parties did cite to it, and so we heard from Mr. Stolz about his opinion. But
Yes, Your Honor. I think that when you look at Held was a Q decision that took place, I believe, after the AMA, and then it involved a Q challenge against a rating decision that predated the AMA. And the question was whether it lied in the AMA world or the legacy world. So with held, I don't think held changes much here, because even in the legacy world of attorney's fees, a Q challenge was considered what we would consider a request for review. It's the ultimate request for review. So all held says is that, yes, under AMA, when you file Q, that is in essence a request for review, and you can get attorney's fees for that. And so I think held really isn't fatal at all to the Secretary's position. It melds with it, and it sort of transitions the idea of a Q challenge being something one can get fees for in the legacy world to having that same principle apply in the AMA world. And, frankly, I think that's what the court should do here with Cameron, Your Honor.
So the unique nature of a clear and unmistakable error is
Yes,
what
Your
would
Honor.
distinguish.
So this is a little bit an off-the-wall question. So, but I've been mulling this over, right, because we're trying to figure out what Congress did. So it clearly didn't, when it was moving the ability to get fees, it didn't go all the way to saying you can have fees for filing the initial claim for service connection, right? It came pretty close from where it started, but it didn't. But I know that there's a large problem out there with respect to predatory, I don't know if you call them claim sharks, or what you do, right? Non-accredited representatives who are filing this, and it's a controversial issue. I'm sure you're aware of what I'm talking about, right? There is a pending statute, the GUARD Act, I think it is.
Okay.
So do we make anything of the fact that if we rule as the Secretary suggests, we are opening another, or we are preserving, depending on how you say it, another area where the claim sharks can swim in? In other words, because an attorney is going to be less likely to be involved if this is an initial thing, and the claims folks, maybe they enter this space more likely?
Well, two things, Your Honor. First, I'm not familiar enough with the claim sharks practices and problems that I really feel like I can speak to it. So, of course, the Secretary would provide briefing if the court would like. But I think that the answer is no, because what happened here would have happened regardless of who files that initial claim for an increase, because as long as you're filing an initial claim for an increase, the veteran gets the benefit of the better effective dates, and the attorney doesn't get a fee, whether they're a claim shark or any other attorney, or any attorney. So really, I don't think that agreeing with the Secretary here opens up any kind of nefarious third-party fee system, because the Secretary is saying there shouldn't be fees here. I think.
Yeah, I mean, as I understand it, and I'm by no means an expert, the way the claim shark works is basically, I'm going to charge you a fee of X amount to do this thing, right? So I'm going to charge you X thousands of dollars to file your claim for service connection, right, at a time when attorneys can't. Right? And as I understand, this is a multi-million-dollar industry that is falling through the cracks in a way, because the VA, by definition, the VA can't do anything to them because they're unaccredited. But because they're unaccredited, of course, they can, avoid some of the stuff. I just wondered if you had a thought about the fact that this would then be preserving another area in which we have this regulatory gap where the Secretary can't police these folks, and we have to rely on the sort of kindness of strangers of the state's attorneys general.
Your Honor, or Congress, you mentioned the GUARD Act, which I'm not really familiar with, but I would hope that there would be provisions in there that would, help with curbing that kind of thing. I don't know that the Secretary's position here would affect it one way or another. I think the Secretary's position here is simply that, an initial claim for an increased rating allows the veteran to get more benefits in terms of the actual benefit, the better effective date, and did so here. And that's the Secretary's job to provide benefits when possible. So because there wasn't a request for review here, the Secretary doesn't think this was a supplemental claim. It was an initial claim for an increased rating. The Secretary's regulation is not inconsistent with the statute, and the court should affirm if there are no further questions.
Isn't the import of held that, like MVA, it focuses us on the initial decision as the triggering event under 5904C1 and not how we characterize the claim?
I think, Your Honor, held does look at the initial decision. MVA does look at the initial decision, but all of them, talk about the idea that you need a request for review. And if they don't talk about it directly, they certainly don't, they're not contrary to it. But I do believe the Federal Circuit talks about needing a request for review in MVA. And really, when you look at that, I think that's where this case turns, is a request for review.
Anything else, Judge Laurer?
No, thank you.
Judge Jaquith? Thank you very much, Mr. Kirschner.
Thank you, Your Honors.
Mr. Stolz, at some point when you're up here in your rebuttal, if you could let me know just the appellant's position about Gumpenberger and whether you think that that's important enough as it relates to this case to wait.
There is no reason to wait, Your Honor. No reason at all. The Secretary's counsel is moving away from the idea that the AMA is supposed to have a streamlined process, and he is doing so by specifically trying to legacyize the words that do not appear in the statutory text. He continuously, throughout his presentation, talked about a narrow definition of appellate review. That definition, my opinion, is coming from the legacy world. The Secretary is insisting upon reading this phrase, appellate review, into a statutory framework in which those words do not appear.
So I follow the second part of the argument. I just want to make sure I understand the first part, right? I understand that one of the legislative purposes behind the AMA was streamlining, right? I'm just having trouble understanding how it affects streamlining one way or the other, whether this is a supplemental claim.
It affects streamlining because of my colleague's entire presentation, how complicated it is for VA to sit down and try to figure out whether it is legally permissible to charge a fee based on words that are not in a relatively straightforward statutory framework. That's all I'm referring to.
Right, although I guess by some, this is going to be probably too cheeky by half, but we could streamline the system by saying a claim for an increased rating is an initial claim. That would streamline it, right? I mean, right. So in other words, unlike something that says by getting rid of the duty to assist, we're stopping the churning. I understand this. I just am trying to understand that whichever way this comes out.
Your Honor's hypothetical proves that that's not. It's not a huge important part of this, the streamlining. It just occurred to me as I was listening to my colleague. But Your Honor's hypothetical proves that point. And what Your Honor's hypothetical was a claim for an initial increase. I understood my colleague as to saying, yes, that's a supplemental claim, but the straight-up claim for an increase is not, because it has this, and again, that proves what is truly more important here, is that the Secretary is reading this definition of appellate review, and again, legacyizing. So the point remains that what the Secretary considers a supplemental claim is not what's in 10136. What the Secretary considers a supplemental claim for the purposes of attorney's fees is a claim based on new and material evidence. And that's it. And that can't be true after MVA and after the statutory framework that was articulated in 5904C1. So with that said, the Board's decision should be reversed, Your Honor.
Thank you, Mr. Stolz.
Thank you, Your Honor.
And so before I say the magic words when hit the gavel, we're going to, after we come down and greet counsel, we're then going to engage in our Q&A right now for folks. Is that right, Tiffany? Well, then with that, I'm going to say that the case is submitted.